Immigration Act. No one must be left behind.
The reason I came to the floor was to discuss an issue which is not uniquely American, but truly American. 528 years now in this place called America, we have had immigrants coming to the shores of our nation. Starting with a fellow named Christopher Columbus, if you buy that side of the story, and I do. They come from every corner of this earth to be part of what we call the United States.
What is employment-based immigration?
Employment-based, or EB immigration, is a program which allows high-skilled workers from around the world to immigrate to the United States and serve the unfilled needs of the U.S. economy. Typically, employers first hire foreign workers on an H-1B visa, which is a temporary work visa allowing the beneficiary to quickly join the sponsoring institution. Later, the employer may apply for a green card for the employee and their family by filing an immigration petition, called I-140 form, to prove the employee's eligibility. Certain individuals with exceptional ability and skills can file an I-140 immigration petition themselves. For some countries, such as France, Germany, Iran, and Japan, over 50% of the applicants fall into these categories. These immigrants help develop the building blocks of technology in engineering, medical, pure science, and informational technology fields. Once a petition is reviewed and approved by USCIS, the beneficiary enters a waiting line for issuance of the green card subject to availability. This is where the problem begins.
You would think with that history that we would have a pretty clear idea of what our policy should be when it comes to immigration. Sadly, you're wrong. We have the most broken immigration system imaginable. I've studied it for years and continue to.
No more than 140,000 employment-based green cards are available each year. So if the approved petitions are more than the available green cards in that year, the applicant has to wait until new green cards become available in the subsequent years. Moreover, to maintain the diversity and prevent monopolization of immigrant visas by one country, a per-country cap was proposed by the Immigration and Nationality Act. In this system, the first 7% of the available visas is allocated to each country. Then the unused green cards are redistributed to high-demand countries. This process protects small countries while still allowing large countries a major share of the visas.
What is backlog in employment-based green cards?
When the rate of immigration from one or more countries is so high that even after receiving unused visas from other countries, still there are additional applicants, green cards cannot be issued to them within the current fiscal year. This new row is called the backlog. Here we're going to address two questions regarding the backlog: how and why.
How was the backlog created?
Let's divide all the countries into three categories and see how backlog is created: India, China, and the rest of the world, obviously excluding the United States. Let's assume there is a flow of I-140 petitioners from each of these three categories into green card application process. Based on DHS data, the average flow of I-140 petitioners from each country other than India and China is less than 0.5% of the total number of green cards for each fiscal year, which adds up to 65% of the total green cards. India and China, on the other hand, initially fulfill the 7% cap. But still, about 20% of total green cards will be unused. These unused visas are allotted to the countries that already fulfilled their 7% capacity, first come, first served. Distributing these visas among India and China approximately receive 20 and 15% of the total green cards each fiscal year. But still, there are a lot more applicants from these countries. These additional applicants add to the backlog each year.
Why was the backlog created?
The cause of the green card backlog is simply a mismatch between supply and demand. The number of applicants is way more than the available green cards. This is just basic math. Every year, about 85,000 new workers are added to the H-1B pool. These workers then seek permanent residence through EB Green Card program. Each H-1B worker has 1.1 dependents on average. That is 178,500 new green card applicants entered into the pool every year, where there are only 140,000 green cards available. The backlog never clears, and it gets worse every year. This figure shows the mismatched number between the number of green cards available each year and the potential green card applicants. The green bars show the number of H-1B applicants and their families each year, and the blue line shows the number of H-1B visa renewals. Renewals are the individuals who are not able to apply for the green card due to a mismatch between supply and demand. Now, compare the green card capacity with the people lined up in the green card application process.
Why is S-386 not a solution?
India currently has the largest backlog. Indian applicants dominate the H-1B program and receive 64% of those visas on average. Without a per-country cap, similar domination would occur in the green card program and severely skew the system against applicants from other countries. With the current cap, Indian applicants still receive about 20% of green cards. Unlike what proponents of S-386 say, the system is not biased against Indian applicants. Removal of the cap will not reduce the backlog, it will only shift it to other countries.
Without any additional green cards, S-386 will not eliminate backlogs for the immigrants, particularly those from India. And there's a large number, over 500,000. And it will dramatically increase backlogs for the rest of the world. The bill puts some Indian immigrants to the front of the line at the expense of every other country. From 2023 until well into 2030, there'll be 0 EB-2 visas for the rest of the world. None for China, South Korea, Philippines, Britain, Canada, Mexico, every country in Europe, and all of Africa. None under the Lee bill.
Particularly exacerbating the GC backlog is the hiring practices of the IT industry. Their business model is based on hiring vast numbers of foreign workers through IT outsourcing companies, most of which are based in India. These companies take a cut from the wage paid by the American employer in exchange for finding immigrant IT workers. These workers are hired with the promise of green cards that never existed, so they get stuck in the backlog and have to work as indentured servants for many years. For example, in 2017, only 7 IT outsourcing companies accounted for 77,000 H-1B applications, that is 161,700 people, including their spouses and children, who are typically added to the EB-2 and EB-3 subcategories with a capacity of only about 80,000 green cards per year. So these 7 companies alone inject twice as many people as the total capacity of these 2 categories. The IT industry is fiercely lobbying against adding more green cards to clear the backlog, and at the same time injects thousands of people into the green card backlog. Why? Because workers in the backlog are technically on a temporary status and do not have the same rights as citizens. Their legal status is dependent upon their employer and its willingness to renew the visa. This situation effectively makes the immigrant worker an indentured servant until they receive a green card. The IT industry makes money by abusing the immigration system to create and sustain this indentured servitude model. In their latest effort, they are heavily lobbying for the bill S-386 to remove the per-country caps without adding a single green card. This move is marketed as an effort to make the system fair. The result would be that applicants from all countries will get stuck in the backlog, which is estimated to be 17 years long. That is 17 years of indentured servitude for everyone.
It would choke off green cards for every profession that isn't in the information technology field. That will include eliminating green card opportunities for those in healthcare, for those in medical research, those in basic science, those in engineering, chemists and physicists.
The brightest and most talented of these immigrants will move to other countries. Their institutions will be crippled and the US will lose its competitiveness in major technologies. Meanwhile, the IT industry reaps all the benefits under the pretense of demanding fairness.
I'm offering an alternative to this legislation. My alternative is basic and straightforward. It would eliminate the green card backlog and treat all immigrants fairly. The Relief Act, which I introduced with Senator Pat Leahy and Senator Mazie Hirono, will treat all immigrants fairly by eliminating immigration visa backlogs. It would lift green card country caps, but unlike S-386, the Relief Act would increase the number of green cards to clear the backlogs for all immigrants waiting in line for green cards within 5 years. Compare that to S-386, the Lee bill, where more than 165,000 Indian immigrants currently in line will still be waiting 10 years from now. The Relief Act will also keep American families together by treating children and spouses of legal permanent residents as immediate relatives, just as the children and spouses of citizens are, so they won't count against the green card cap.